Breach of trust in South Carolina is a criminal charge where you have lawful possession of another person's goods or property, and then you convert those goods or property for your own benefit, depriving that owner of possession. Hi, my name is Dale Savage, and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about breach of trust charges, which can be either a misdemeanor or a felony, depending on the amount involved. For the state to prove breach of trust, they have to show the following: that you're in lawful possession of the goods or property, that you were entrusted to be in possession of those goods or property by the owner or their agent, that you converted that property to your own benefit, and you had the intent to deprive the owner of that property, or you hired or canceled someone else to do that for you. Now, depending on the amount involved, it can be either a misdemeanor or a felony. What does it mean to be entrusted with another person's goods or property? Essentially, what this means is that you had permission or the owner's consent to have lawful possession of that property, and you were supposed to act for the benefit of that property owner. The scenario where these cases typically arise are in the workplace, where someone is in charge of goods or monies, and then they take that money and use it for their own benefit or purpose. A number of these cases typically involve someone that's working in the accounting department of a business that has access to the funds in the business, and then they convert that money for their own personal benefits, such as paying their mortgage, paying for vacations, buying clothes, shoes for themselves, buying vehicles for other people. And that's how the amount in controversy sometimes can be in large sums, because the cases don't get discovered until maybe there's an audit in the accounting department, where an outside person comes in and looks at the process and procedures and then discovers the crime. What's important to understand is that these cases aren't just limited to private businesses. It can often happen for government offices as well. Surprisingly, I've seen this even happen in police departments, where someone was working under the chief of police for a local department here in Charleston, and that person was committing breach of trust for a number of years, and it wasn't discovered until an outside audit took place, and then the crime was uncovered, which had been going on for years. No one suspected that someone working for the chief of police would go ahead and do such a crime, but it does happen. What's also important to remember in cases like this, it doesn't matter if you get caught and then agree to, or you do pay back all the money that was taken to the business. It's still a crime. The fact that it's already happened, giving restitution back does not mean the cases get dismissed. Now, that can certainly help when it comes to sentencing and using that as a factor for mitigation to the court, but it doesn't mean the case gets dropped. One of the most important things to defending these cases is to force the state to show that there was a trust relationship established between the person accused and the property owner, and then that the person that is alleged to have taken that property was the actual person who did that. It's not enough that the property owner just has a hunch or suspicion that you did it. They have to show that you are the one who actually converted those funds for your own benefit and deprived that property owner permanently of it. So, if you've been charged with breach of trust and would like to discuss your case with me, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.